22189-FH, People versus Trevor John Voss. We are here today for a pretrial in this case, and we're proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda, you wait for Mr. Voss this morning, Your Honor.
Where do we stand with Mr. Voss's case today, Ms. Underwood?
Your Honor, Mr. Voss has slowed down a little in payments. He had a rough works series, but it has gotten back to a big job is paying out. So Mr. Voss paid $600 cash at the front of the court yesterday, Your Honor, and he should be able to make another $600 payment within the next 2 weeks and get himself back on track. Also, Mr. Voss did go to the Sheriff's Department about fingerprints, but he has to have his paperwork and go to the jail and also have the money to get that done, Your Honor. So he's working on that. And Mr. Voss needs to go to the front of the court and open up his review, Your Honor. That is closed.
Yeah,
So
I tried doing that. They canceled it.
Right, they
I
canceled
signed-
it because you didn't turn in the paperwork, I believe. So you need.
No, I
to
turned
do
it in.
that.
I turned it in. They said it didn't give
Well,
it a
Mr.
good
Voss,
reason.
Mr. Voss, if you want your child support amount lowered, you need to do whatever you need to do with the front of the
Oh,
court.
of course. I'll definitely do it again.
They usually do not just arbitrarily cancel hearings or petitions that people file without a reason. So if you need to file it again, then you need to file it again.
Yes, sir.
And Your Honor, so we would be requesting just maybe a 45-day adjournment to see that we have movement on these things, and I think we can get things accomplished.
Ms. Brenner?
Your Honor, if what Ms. Underwood is saying is accurate, then I would agree. I cannot get any information about a payment he made yesterday, so I don't know if that's true or not. I can see that they closed his review because he failed to provide any financial information. So I don't know that they're going to reopen it this quickly, but that's neither here nor there. So I would agree to 45 days. If he's not making payments like he's informed his attorney, then we're going to have a problem when we come back.
All right, so what I will do is adjourn this to September 3rd at 8:15 a.m. At that point, if we don't have substantial progress, I would be in a position where I'm going to set it for trial, or we need to move forward in one direction or another.
Thank you,
I
Your
think
Honor.
I might have my receipt for the payment. I'm looking to see if I can find it real quick. But yeah, I got a receipt
It's
for
fine.
it yesterday.
I'll see that it happened. If it happened, I'll see it. So
Okay.
thank you, Judge.
All right, so September 3rd at 8:15 is your next date, Mr. Voss.
And I will
Thank
be
you.
happy to do the stipulation and with Ms. Brenner's permission.
Yes, Rhonda, thank you.
Thank you, Your Honor.
All right, Mr. Voss, you can go ahead and log out then. Ms. Underwood, do you need to speak to Mr. Broughton?
Yes, Your Honor, just briefly.
And Mr. Fry, who else do you have today?
I have Anthony Wilson Clark, who's here in the courtroom, Your Honor. Then I have some people in jail.
You have Mr. Coble, so you can
Bogle,
Mr. Coble.
and Edward Edwards.
Yes, please. Okay, we can do Mr. Watson Clark's case. This is file 25-22230-FH People versus Anthony Wayne Watson Clark. We are here today for a pretrial conference in this case, and we're proceeding today partially in person and partially by video conference. We're going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, map the people.
Good morning, Your Honor. Brian Fry, appearing for Anthony Watson Clark.
Mr. Fry, where are we with Mr. Watson Clark's case today?
Yes, Your Honor. So we've come to an agreement with the prosecutor where my client is going to do the diversion program with the prosecutor's office. So he, I've discussed with him, he's gonna be contacting Bob Wendt over there to get that started. It is a good chunk of money that, he's gonna have to come up with as part of that program. So we would request that the court set this out like 3 months or so, just to gauge his progress, but when he's completed that, the case would be dismissed.
And Your Honor, I would just counter that by saying I would typically, we do come in with these agreements, but we do like to monitor them a little bit. So I would just ask for a 30-day adjournment to make sure he's started in the program. And if he is compliant at that time, we could just do a stip in order to adjourn for either 3 months or 6 months at that time.
Okay, I'm a little bit confused. The file I have in front of me is an assault with a dangerous weapon charge.
That is the charge, Your Honor, yes.
Okay. So 30 days.
Yeah, and then we may not necessarily need that pretrial if he's compliant. We could just do a stip in order to adjourn.
Okay.
I'm agreeable with that.
Closest I can get to that looks like August 27th. So let's do August 27th at 8:15. And Mr. Fry, would you be able to do that stipulation in order?
Yes, I can do that. Ms. McClure, could I sign your name with permission?
Yes, no objection.
Thank you.
Okay, so Mr. Watson Clark, your next date is August 27th at 8:15 a.m.
Okay, sir.
Thank you. Okay, Ms. Underwood, are you ready to proceed with Mr. Broughton?
I am, Your Honor.
This is file 25-22202-FH, People of the State of Michigan versus Cameron Joseph Broughton. We're here today for a pretrial conference. We are proceeding today by video conference. First, can you have the attorneys place their appearances on the record?
E.B. McClure, map of the people.
Rhonda, I'll do it on behalf of Mr. Broughton, Your Honor.
And where do we stand with Mr. Broughton's case today, Ms.
The
Underwood?
offer in this case from Mr. Sneed is as charged, no supplements, Your Honor. Those would be dismissed to one count of a prisoner possessing a weapon, a 5-year felony, and there would be a killabrew, Your Honor, to the low end of the guidelines. And I believe Mr. Broughton wishes to accept that offer today.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
Your Honor, I don't see a plea form in the file for Mr. Sneed, and I don't see a Killebrew in his notes. So I'm not sure, I guess.
Then, I don't know how the court is doing advice of rights with MDOC people, but perhaps we could have a short adjournment, Your Honor, and these things could all be worked out and we can come back in an upcoming date.
Okay. You know, we unfortunately don't really have a system for working with MDOC that I'm aware of for the new advice of rights requirement, other than I suppose we're going to have an in-person writ for Mr. Broughton at the next hearing, so that we can have that form signed at the time that he takes his plea.
Excellent, Your Honor.
So why don't we adjourn this to August 27th, and Ms. McClure, the prosecutor's office, do an in-person writ for Mr. Broughton for that day.
Yeah, we can do that.
And I will be happy to do the stipend to adjourn with Ms. McClure's permission.
No objection.
Okay, so we'll go with August 27th at 8:15 a.m.
Thank you.
Okay, Mr. Broughton, you are all set with court for today. You can let the officer with you know that you're done.
Thank you, Your Honor. Have a wonderful day.
Thank you, you too. Okay, Mr. Edwards, do you want to come forward? You can sit at the table here closer to the television. And Ms. Espinoza, if you want to come forward, you don't have to, but if you want to, you can sit at the table closer to the jury box. This is file 25-52645-PP, Juliet Espinoza versus Terrence Edwards II. We are here today for arraignment on a alleged violation of a personal protection order, and we are proceeding today in person. Miss, you are Juliet Espinoza, and sir, you are Terrence Edwards II. Mr. Edwards, have you received a copy of the order, the motion in order to show cause? Yes. That show cause alleges that you violated a valid personal protection order on June 23rd, 2005, by being in the presence of Ms. Espinoza and throwing a drink in her face. The maximum possible penalty for violating personal protection order is up to 93 days in jail or up to $7,500. You do have the right to be represented by an attorney at this hearing and at any other hearings that we might have regarding this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you from the public defender's office. Do you understand that? Yes, sir. Do you want to be represented by an attorney today?
Not today.
Okay. Do you understand that you have a right to contest the violation personal protection order charge and to have a trial on it? Yes. Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt? Yes, sir. You have the right to have all the witnesses against you appear at your trial. You or your lawyer, if you had one, could ask those witnesses questions. You also have the right to have me order any witnesses that you have for your defense to appear at your trial. You understand all of that? Yes, sir. You're not required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that? On the other hand, you would have the right to testify if you wanted to testify. Do you understand that as well? Do you know how you want to plead to the charge that you violated personal protection order? Yes. So you are aware that a personal protection order was entered in this case back on May 12th of 2025. I'm sorry, May 13th of 2025. Is that correct?
Correct.
And at some point, was a copy of that served on you?
Yes, it was.
Did that happen on May 26, 2025?
So,
Okay. If there's a proof of service in the file that says it happened on May 26, would you have any disagreement with that? Okay. So you received that at some point before June 23rd, is that right?
yes.
And at June 23rd, were you in Ms. Espinosa's presence at a park?
Yes, okay.
And did you throw your drink in her face?
Yes, it did.
Okay, and it hit her?
Yeah.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Edwards has had full knowledge of his rights, and he has made a knowing waiver of representation by counsel. Is there anything, Mr. Edwards, that you would like to say before the court passes sentence? Ms. Espinosa, is there anything that you would like to say before the court passes sentence?
Briefly,
Go ahead.
so this has been a pattern of escalating behavior since November. It's just been getting worse and worse. The PPO was granted because he was threatening to kill me. And I don't feel safe around him. I don't feel safe in my home. We've had to install cameras, buy pepper spray, things like that. I'm scared to go in public. My anxiety is through the roof, even now, being in the same room as him. And I want it noted that he's been able to torture me for the last 6 months with no repercussions.
Okay. Say, Mr. Edwards, is that the circumstances that led to the entry of this personal protection order were concerning to me. Obviously, that's why I entered it. To know that you were in her presence and frankly assaulted her, which you did meets the definition of an assault and battery. And that gives me a very good deal of concern about how to move forward, because it doesn't appear that you're getting the message. And the message is, you will not be around her under any circumstances. Even if she calls you, she probably doesn't sound like she will, but even if she calls you and says, come over, I want to spend time with you, you can't do it because of this court order. Normally, in situations similar to this, on a first violation, what I do is assess a fairly nominal fine with a warning that if things go forward and there's another violation, that the consequences will increase. And I'll start to think about using the jail time that is available in these circumstances. Right now, in your circumstances, this is causing me to think about whether I should use jail right now. Because somehow it's got to get through to you that you cannot be in contact with her. Other than my text message, as it's stated in the order. What I'm going to do at this point is assess a fine of $300. And you need to know, Mr. Edwards, that if you are back here in this circumstance again, the most likely outcome, if you're guilty of a violation, particularly if you're actually in her presence and do something to her, will be a jail term. So for today, it's a sentence of the court that you pay a fine of $300 within 30 days of today's date. All right. So we're all set for today. Thank you. Gentlemen, you know, I have the LCJ device log and the camera's off. Okay, Mr. Dagger Margotian, you have one of your clients is here in person.
George McDonald here.
McDonald.
He
Okay.
has the LCJ device locked. LCJ device. Because we don't. All right, thank you. Bye.
Is file 25-22278-FH, People versus George McDonald. We are here today for a pretrial conference. In this case, there's also pending show cause for violating bond conditions. We are proceeding partially in person, partially by Zoom. First hand, the attorneys place their appearances on the record.
Stevie McClure, map the people.
Your Honor, Mike Dagger Margosian for Mr. McDonald.
And Mr. Dagger Margosian, where do we stand with Mr. McDonald's case today?
Your Honor, regarding the pre-trial, I'm asking the court to set this for a jury trial, please.
Okay, and Ms. McClure, how long do you think we'll need for a trial?
Let me peek at this again. This is Mr. Sneed's case. So let me just look at the witness list briefly. I would say just a day.
Mr. Dagger Margosi, do you agree?
I think that's fine.
Okay, so Francis, could we have a one-day jury trial date, please?
All righty, Mr. Goble, we're gonna move you rooms, so you have a better shot at your.
Francis, are you there?
She's running back to her office right now.
Okay, thank you.
Yes, Judge.
We need a one-day jury trial date, please.
We could do Thursday, September 25th at 9 a.m.
Can you hear better now? All right.
Appears to work for Mr. Sneed.
September 25th. let's do a final pretrial on September 17th. The court will issue a scheduling order. Is there anything else that we need to address today?
No.
Nothing on behalf of the people, thank you.
Okay. Thank you. I think we're all set. So we'll adjourn the show cause hearing to the final pretrial date.
Thank you.
Okay, then you have Mr. Coleman also, Mr. Dagger.
I do, he's in rehab. I don't know if he's on Zoom.
Okay. Let me. One person. Unidentified. Okay, to have someone that just joined the meeting on a Samsung device, I need you to turn on your video and unmute your device, please. Need you to unmute your device.
Do I need, he's telling you to do something.
Okay. And sir, you are Joshua Coleman?
Oh, that's a different.
Yes.
Oh,
Yes.
that is a-
You hear me?
Okay. Yes. All right, Mr. Dagger Margosian, are you ready to proceed with Mr. Coleman's case?
Your Honor, we are, however, so the I don't know if you want to call the case right now, but.
Yeah, I guess let me do that. So this is file 25-22283-FH and 25-22320-FH, People versus Joshua Glenn Coleman. We are here for pretrial conference in the 25 case and I'm sorry, in the 283 case and an arraignment in the 320 case. First, can I have the attorneys place their appearances on the record?
Phoebe McClure, of the people.
Aaron Michael Dagger Margosian for Mr. Coleman.
And with respect to the 320 case, Mr. Dagger Margosian, does Mr. Coleman wish to have that information?
No.
And how does he wish to proceed on that case?
Regarding the arraignment, we're entering not guilty. We do have a resolution on both cases. However, he pursuant to Newport rules, obviously we do have to get that device rights in. So him being at rehab doesn't lend that itself to that. What I would ask the court is I could log on to Zoom, verbally read over the form with him.
Unfortunately, I don't think that works under the rule because what the rule says is that the person has to be advised in writing, both on the record and in writing. Is there a contact or somewhere we can email that form?
Maybe ask Mr. Coleman.
Mr. Coleman, is there somewhere where we could email or fax that form to the facility that you're at and they would be able to print it?
Yes, 1 second. 1 second.
Okay.
Thank you, Tara.
Okay, it is 734.
Okay,
669.
one second,
This is the facts.
okay, yeah, one second, Mr. Coleman, let me stop our live stream because